CCT, you see this?
Look, if it ain't official Dana J, Levi for Kelly, Prima Donna News, I don't even want to see it. Just take the phone.
So if you are allowed to represent yourself in this case, sir, you will not have attorneys assisting you. If I let them withdraw, they're gone from this case. Do you understand that?
I think I will probably be better served representing myself.
Mr. Brooks, please stop.
No, ain't no please.
You are
nothing.
being disruptive.
Ain't
You
no
are being
please,
disrespectful.
You always
The
gonna
witness
find
may
some
step
reason to
down.
say somebody's being disruptive because they want the truth to be out there. Man, quit it. You supposed to be the
Mr.
judge.
Brooks, I'm advising you that continued interruptions will result in you forfeiting your right to be present in this courtroom.
Under what law and fact can you do that?
Illinois versus Allen.
Okay,
sir.
what the fourth option that you made up that's not even in the law?
Mr.
Because
Brooks,
you can't do that.
I need to make a
By law, you
ruling.
can't do that.
I need to
And
make
you
a
know you
finding.
can't.
All right, I'm going to excuse everyone. Mr. Brooks is being removed from the courtroom. He will continue in the neighboring courtroom. Please make sure he has his objection signed and a pad of paper. The court is going to continue with the direct examination by the state of Detective Carpenter. I would like you to come back to this courtroom. Are you willing to conduct yourself consistently with the decorum and respect inherent in the concepts of courts and judicial proceedings?
I didn't do anything to be held in contempt in the first place.
So are you willing to abide by the rules of decorum and civility? I would direct your attention to SCR Chapter 62, which has been provided to you previously.
Does that say anything in there about me being held in contempt?
That does not, no.
So why have I been held in contempt?
I didn't hold you in contempt, sir. You are simply in a different courtroom based upon your disruptive behavior. I'm giving you the opportunity.
Has not been disruptive.
I've put my findings on the record, sir, and the record stands in that regard. I'm giving you the opportunity, if you can, indicate to this court that you will conduct yourself with courtesy and decorum. Are you willing to do that, sir?
Is Your Honor willing to tell me why I've been held in contempt?
So that the test result could be obtained and if necessary by reasonable force. It's my understanding there was some type of situation or altercation between Mr. Brooks and the deputies. Ultimately, though, I think he was taken into the bullpen. He was brought back out, but it was very clear to me that he was upset. I think understandably so, but I needed to make a record of what was being done, including that I have obtained the test result, so there's an accurate record in this case related to the motion that was raised previously by Mr. Brooks. I want Mr. Brooks to know that I am not removing him from when the jurors are brought back in. It was just simply because he was upset. He was very loud when I walked into the courtroom before going on back on the record. He was yelling about his constitutional rights being violated. I advised him that if there was any type of use of force that he wanted to complain about, he could certainly do that through the proper channels with the sheriff's department, but just given his state of agitation and my need to make a record, I had him taken to the other courtroom. He is currently muted. I do not intend to go forward with additional testimony. Ultimately, I'm going to take an early lunch break because of this, but I will make a record of the following. I have your choice, though. Are you willing to go back to your cell and put on your suit?
It is my right to do so or to not do so. And at this point, Your Honor, who doesn't know that I'm in custody?
Mr. Brooks, I've had many trials with individuals who were in custody, and when I've talked to the jurors after the conclusion of the case, they had no idea. The whole point of allowing for street clothing is not only to shield jurors from the fact that you are in custody, but also you being in a suit and a tie or other street clothing, I think also lends to the dignity of the proceedings. This is a trial. Again, it is your choice. Are you willing to go back to your cell and be dressed in the street clothes that you previously appeared in?
With all due respect, I do not agree with that assessment whatsoever. There's no possible way that anybody will not know that I am in custody. I think that's a well-known fact because it's reported on every day in the media. It's shown every day on the news where I am, what jail I'm housed in, and that I'm in custody. It's virtually impossible for anybody to not know that I'm in custody.
Back on the record, appearances are as they were before. I need to make a record that at 8:42 a.m. this court ordered Mr. Brooks be removed from the courtroom due to repeated interruptions and disruption with the court. This, of course, comes on the recent history with Mr. Brooks. On every day that we have been in court since Monday, he has shown a complete and utter disrespect for the simple rules of civility. He has been removed from the courtroom multiple times. This morning alone, he started interrupting this court within a minute of the court calling the case. I should also make a record at the moment he is muted because of the way that he was removed from the courtroom and his conduct since. I have been given just a bit of information about it. I will advise everyone that I have required that the Sheriff's Department file a written report with the court regarding Mr. Brooks's conduct. I'm told that he would not sit down while in this courtroom in order to have the shackles removed so that he could be taken to the other courtroom, that he was resisting, that at one point he took off a shoe and it appeared to the deputies that he was going to throw the shoe.